Good afternoon, Mrs. Fallon. My name is Paul Cookson. It's nice to meet you. Do take a seat. I understand you're being threatened with legal action. Is that right?
Hello, Mr. Cookson. Yes, that's exactly right. I spoke with your colleague on Tuesday morning and he said to come and see you.
Well, I work in the litigation department of the firm, which is why your case has been passed to me. Please, try not to worry. I've had a quick look at the details you've provided so far, and I'm confident we can get this resolved quite quickly.
OK, sounds good.
Great. So I see that you run your own landscape gardening business as a sole trader. When did you set up the business? I seem to have two dates, March 2007 and October 2012. Which is right?
The latter. I was employed up until the 16th of August 2012 with a big landscaping firm. I started with them in March 2007, but I was made redundant after 5 years. So, after unsuccessfully looking for another job, I started my own business on the 1st of October of that year.
Thank you. And what's the name of your business?
It's called Four Seasons Gardening Services. I'd worked pretty much flat out, 7 days a week when the work was there, and it was going really well. Until recently, that is.
When you agreed to do some work for a Mr. Trevor Morgan?
That's right. He and his wife have got one of those big 5-bedroom houses next to Victoria Park. He'd asked if I'd be interested in doing work on the garden. He wanted it finished by September this year as a gift for Mary for the 25th wedding anniversary. It involved planting a new rose bed with about 50 roses, those expensive David Austin ones that the Queen has, if you know them. He wanted the ones called Mary's Delight. £40 each they are, but I get a decent discount on them. Also, a big decking area with garden seating and a little fountain.
And you accepted the job?
Yeah, I've known Trevor and Mary for years, and it was a good job to get in the autumn when I don't normally have much income. People tend to start saving their money for Christmas from September onwards.
And did you agree a fixed price for this work?
We did. For a job like that, I would usually charge about 7,500, but I agreed to do all the work at mates' rates, so we shook hands on a price of 6.
And did you have any kind of contract drawn up?
Not one from a lawyer, but Trevor typed up a 1-page document and we both signed it. I think he was scared I was going to charge him full price once the work was done. He's always been careful with his money. We agreed the price, the start date for the work, which was the 13th of June, and a finish date of the 31st of August.
But in the event, you didn't start the work.
I didn't, unfortunately. That's because when I was working on another job at the end of April, I badly injured my back lifting some heavy garden furniture.
Oh no, that doesn't sound good.
It wasn't. I was in bed for over 2 months. In early June, I tried to do a few small jobs, but it was impossible. The doctor finally advised me against doing any more physical work at all.
When did the doctor advise that? Have you got the date?
I have, the 3rd of June.
I see. So when did you inform Mr. Morgan you could no longer do the job?
The very next day. He reacted badly. He said I'd really let him down and that he wouldn't have time to find somebody else to do the job on time.
And the next time you heard from him, it was through his solicitor. Is that right?
Yeah. I got a letter dated the 12th of July from a lawyer saying that I'd committed a material breach of the contract, whatever that means, and that I'd have to pay him damages.
Remind me what they're claiming.
7,500 to pay somebody else to do the work and 1,000 for the disappointment he'd suffered, as he now won't be able to find anyone to complete the work on time, plus legal costs, whatever they'll end up being.
Well, the good news is I think we can argue that you don't have to pay anything at all. A material breach is a breach that the law regards as sufficiently serious to justify termination. But in your case, despite the alleged breach, I believe we have strong grounds to argue that the contract has been frustrated.
What does that mean exactly?
Well, a contract has been frustrated if something happens to one or both of the parties that's beyond their control and makes it impossible for the contract to be performed. If successfully argued, it means the contract can be set aside as if it were never agreed.
And will injuring my back be enough for us to argue this?
I believe so, yes. There's a very similar case to yours called Atwell versus Rochester. This also involved a sole trader who was contracted to complete building work on a family home. However, he unfortunately suffered a heart attack and the doctor advised him afterwards not to continue to work. He argued on this basis that the contract was frustrated. The judge agreed.
Oh, that sounds just like my case. I feel so much more positive now. So, what happens next?
Well, if you decide to instruct me, I'll write to his lawyer to explain our position. I'll say that Mr. Morgan has no real prospect of success if the case should proceed to trial and ask that he therefore discontinue legal action.
Thank you. I'd like you to go ahead and do that.
OK, great. I'll just get the paperwork for you to sign to formally instruct me. We'll have this sorted out in no time at all.